Hi Millie, how are you?
Good day, Mukesh. I'm well and yourself.
Okay, so what is the topic for today that you are going to
Today,
present?
I'll be presenting on alternative dispute resolution. I'll go through the different types of alternative dispute resolutions. We'll have a focus on arbitration specifically. We'll talk about what arbitration is, the benefits of arbitration, the consequences of arbitration. We'll talk about what is excluded from arbitration and also whether arbitration can actually be appealed or not once a decision has been granted.
Okay,
All right. Alternative dispute resolutions is alternatives to to litigation. Litigation is when you have a court case against somebody which will be presented in court, and there will be a judge or magistrate that presides over that matter, and they will make a decision at the end of all the submissions, the pleadings, the examination, the cross-examinations, or the evidence submission. The court then comes up with a decision regarding that particular matter. So that would be litigation. So companies sometimes require a method that's different from litigation because litigation requires a lot of time and costs quite a lot of money at times. They will then opt for alternative dispute resolution methods. In South Africa, there's mediation. Mediation is when a third party will have a discussion with the two parties that have a dispute, and they will then facilitate the discussions, and the parties will come up with a solution in terms of how they want to deal with the disputes. There's also negotiation, which will be a discussion where the two parties will have discussions and they will voluntarily reach a mutual agreement that they think is beneficial to both parties. There's also conciliation. Conciliation is is a dispute resolution discussion as well, where that is done by a third party. In conciliation, the conciliator can make recommendations in terms of what a solution can actually be reached or what solution the parties can come to. The last one is arbitration. Arbitration is formal. There are regulations that actually govern how arbitrations must be done. There's different types of associations as well that follow arbitration procedures or that do arbitrations. In South Africa, we've got what is called the Arbitration Act, which governs how arbitration is done in the country. Arbitration is when a third party is involved, called an arbitrator. This particular person will most likely be skilled and knowledgeable in that particular matter or in terms of the dispute that that particular party or parties are presenting. It can be one or up to three arbitrators that are involved in the proceedings. They will then listen to what the parties present as their disputes and their claims and their evidence. And at the end of all the discussions and presentations, the arbitrators will then make a decision. What is important about arbitration is that the decisions that are made are actually final. The arbitrator or arbitrators can make an award, which would be granting one of the parties a claim, as they would be bringing the matter to arbitration so that they can claim something from the dispute. That agreement, that decision is final. It cannot be appealed. However, it can go to review if one of the parties feels that there was some disparity or there was some bias in the decision making of the arbitration process. There's also different types of situations that arbitration can actually accommodate. What is excluded from arbitration? Criminal offenses are excluded from arbitration. Matrimonial issues are excluded. and also matters that involve guardianship are also excluded from arbitration. In most cases, arbitration will be used for commercial purposes where there's a dispute that could arise between parties that have a commercial contract with one another. However, it's not limited to commercial contracts. The exclusions that I've mentioned are the only ones that are excluded from arbitration. As I mentioned, matrimonial issues, guardianship issues, and criminal matters are excluded from arbitration. What are the benefits of arbitration? Compared to litigation, arbitration is cheaper. It can offer the parties that have a dispute a quicker solution to their problem. It can assist them in maintaining the relationship that they have with one another because it's less aggressive. They can still be able to work together after the matter has been settled. It can actually help bring a resolution faster than litigation will take. Normally, arbitration processes don't take longer than 2 years. It can also help parties that want to prevent the matter from being known publicly. So it provides confidentiality. In some cases, companies respect their confidentiality because if a matter comes out that might then expose them to the public and it might affect their share prices, it might affect their deals or contracts with other suppliers or clients that they might be trying to enter into contracts with. So arbitration can help prevent the reputational damages that litigation actually can bring about if a matter goes to court. So it is actually quite beneficial to consider arbitration. In some cases, it is actually advised that arbitration must be dealt with or must be mentioned at the onset of a commercial contract being entered into. This would be an arbitration agreement that is included in the contract, and it would be stated as the dispute resolution mechanism that would be used should a dispute arise at any point during the contract life cycle between the two parties. Because a dispute can arise at any point. Initially, all parties have a good intention when they enter into the contract, but somewhere along the line during the contract life cycle, a dispute could arise. So it helps the parties if they have already mentioned that instead of litigation, they will actually go for arbitration. So in the arbitration agreement or clause that must be mentioned in the contract, they will state who the arbitrator will be. They can decide on the onset who they want to arbitrate the matter. They can also decide the seat where the arbitration will take place. They can also decide on the language that will be used. They can also decide on the terms that will be followed before the arbitration happens. In international contracts, the seat of arbitration refers to the venue where it is going to happen. If parties are multinational companies, they can decide to have arbitration in any country of their choice. But by doing so, they'll also be deciding on the jurisdiction. The jurisdiction will be decided by the location. If they decide that arbitration will happen in England or in the UK, English law will therefore be the law that would be applied during the arbitration. That also means if English is the language that is spoken there during arbitration, if they've chosen English, then that's the language that will be spoken. So these are important factors to consider because a party must ensure that if arbitration happens, it must also work in their favor in terms of they want to have an arbitrator that will be knowledgeable and will be able to understand the matter for what it is, because not everybody has the expertise to understand every single type of dispute. They therefore have the right to choose the skills set that they want the arbitrator to have. And they can also interview the arbitrators when they select arbitrators in terms of understanding whether they actually are the correctly qualified arbitrators to hear the matter. These issues can reduce the strain that companies can face if they are dealt with in advance at the beginning of the contract and not only decided once the dispute arises. Further, in terms of the arbitration itself, there are processes to be followed in terms of how to actually carry out an arbitration. Before a party decides on arbitration, they have to notify the other party that they actually want to refer the matter to arbitration. When the matter is referred to arbitration, where there is an arbitrator selected, they will have to submit what the dispute is about. They will have to indicate when the dispute occurred. They have to submit the agreement as well that is referred to, as the agreement will be the one that indicates what the initial agreement was. If parties agreed that party A is going to supply party B with materials that are specified, that have specific dimensions or they have specifications that they must meet, they must attach that. If their claim is that party B did not honor the agreement that they had actually entered into, and they must also indicate what their claim is, because when they refer the matter to arbitration, they would want compensation for the failure of the other party to honor the agreement. The intention of arbitration is to be able to get something out of the contract and not lose altogether. Sometimes it might go as far as claiming for future income. If party A feels that the lack of party B's performance or the partial performance or the faulty performance of party B has caused them a loss of income, they will also indicate that as part of their claim, and they will quantify what they believe is the correct amount for the damages that they have suffered, and they will submit that with their request for arbitration. Party B will have the right to prepare for arbitration as well. They will receive the notice from Party A, and they will also then prepare their response to Party A. They will either send the response within a certain number of days, if that has been stipulated, or they will respond to the arbitration notification itself that will come from the arbitrator providing the details of when arbitration hearings or the sitting will happen. At this point, both parties must be aware that there is an arbitration process that must happen. Where there is an arbitrator already, the arbitrator will be notified and they will know, and they will provide dates and time when the pleadings or the presentation of the arbitration will happen. And they will decide and determine, after listening to both parties and receiving all the evidence and all the information that is necessary, they will then come to a conclusion on what they think must be done, and they will they will give an award to the party that they feel needs to be compensated for the dispute. This decision will be final, but if there is a party that feels that the arbitrator was biased, was not impartial, they can then refer the matter to review. There is a particular case that has happened in South Africa in the mining industry, where the parties to the arbitration, one of the parties decided that they wanted to take the matter to review, and they've actually gone to the Supreme Court of Appeal, where they indicated that the arbitrator decided that they were not going to listen to the claim that they were making against Party B. They said that the party had repudiated the contract. So that was their defense for their part in the dispute. But unfortunately, the arbitrator said that because they had not submitted that defense in their pleadings, they would not accept that. And therefore, the claim was awarded to Party B. When they went to the Supreme Court of Appeal, the Supreme Court of Appeal also upheld this decision as it was in line with the provisions of the procedures for arbitration. They also agreed that the arbitrator did not have jurisdiction to continue to accept the claim for repudiation as it needed to form part of the pleadings. Arbitration is an international concept that can be applied in any jurisdiction. It is known all over the world as a solution and an alternative to litigation. And it can be beneficial to a lot of companies if they apply it, especially if they can address it in the onset of a contract so that they know that should there be a dispute that arises between them, arbitration will be the way to address that dispute resolution. Every country has its own regulation on how arbitration rules must be handled. The common aspect of arbitration will be that the arbitrator must be impartial and it must assist the parties by coming up to a decision that will be final. I'm not sure about other countries if that decision would not be final, but in South Africa, the decision of the arbitrator is final. Also, in international arbitrations, any party that has been awarded the claim has a right to enforce that claim in any other jurisdiction where they could have other operations. It does not necessarily have to enforce it in that particular jurisdiction. If they choose that they want to, if the award was perhaps granted in the UK and they have operations in South Africa, they can choose to have the court enforce the award in South Africa. However, they will have to have that judgment recognized in South Africa before they can actually enforce it. And finally, enforcement of an award that has been granted by arbitration can only be done by the court. It must be enforced by the court. The arbitrator can grant it, but they cannot enforce it. It requires the court to enforce the order. Thank you.
Okay, so it was all about the arbitration under the heading of alternative dispute resolution, right?
Yeah.
Okay,
Yes.
thank you so much. It was nice to having the experience, a different experience about the term. Okay, so uh, can you tell me what are the mode of alternative dispute resolution? Those are practiced in your country.
So as I mentioned, the different types of, well, arbitration specifically, I didn't go into different types of arbitration. I only looked at the different types of alternative dispute resolutions. So in this particular presentation, I was looking at commercial arbitrations.
Fine, that is okay. But what are the major types of alternative dispute resolution? That is the main heading.
So yeah, so mediation, conciliation, negotiation, and arbitration, which I mentioned as the different types of alternative dispute resolutions.
Mediation, conciliation,
Negotiation
negotiation,
and arbitration.
okay, and arbitration. These are the four types of alternative dispute resolution, right?
Yes.
So,
Yes.
so I have, though you are just focused on arbitration only, but apart from the arbitration, can you explain briefly what mediation is, what conciliation is, what negotiation is, how these three terms have different meaning or different mode of resolving the dispute?
Yes. So the other three methods, they're different from arbitration, number one, in that they are not as formal as arbitration is. And whatever results from that discussion, it's not a final decision that can be enforced by the courts. With mediation, the third party is there to facilitate the discussions. They don't tell the parties what to do. The parties will reach an agreement through the discussions. With negotiations, it's also very informal. The parties voluntarily decide that we want to sit together and we want to discuss it. We want the third party to be present to assist us in the discussion, but they also don't make any award regarding the discussion. The parties will have to reach a mutual agreement that they will both feel is satisfactory for them to resolve the disputes. With a conciliation, it's similar to mediation. However, a conciliator is not only facilitating the discussion, but they can also make recommendations to the parties in terms of how can they resolve the the dispute. Yes. So arbitration is the one that stands out because it can actually help the parties by making a final decision and awarding a claim that is enforceable by the law, by a court.
Okay. So, but still, I have confusion regarding the difference between conciliation and negotiation.
So with negotiation, the parties are the ones that actually decide. The the negotiator or the third party is really just there to facilitate their discussion, but they don't make the decision. The solution must come from the parties at the end of the day. The parties must be willing to give and take. That's the negotiation part of it. They must be willing to sacrifice something and give something and get something. At the end of the day, it must be a win-win situation for both parties.
Okay. So,
With the conciliation, they
yes.
will also reach an agreement, but it's not an agreement that the conciliator will be giving them. They will only guide them in terms of what could be possible solutions that they can consider. And it's also not a binding agreement that the conciliator will say this is final and enforceable by law. So the duty then on the parties to whatever decision they come up with when they are either doing a mediation, conciliation, or negotiating, to reduce it to writing so that it is binding on them. But it's not something that is binding because the third party has said that this is the decision.
Okay. That is up to the parties whether they accept it or not. Right.
Yes,
Okay.
yes,
That's fine. Okay, so arbitration is something like more into commercial kind of dispute or business dispute
yes,
or something like that.
yes,
As arbitration is more formal, so it is for the formal disputes. You can say like that. The companies and the
yes,
businesses are involved when come across with the dispute, then they can go through this process rather than going through the
yes,
litigation. Okay.
yes,
You know, arbitration there I don't know whether what about in South Africa, but in a even in an international business or something like that where people coming together, they are making agreement to do the business together, they essentially add an arbitration clause. If
yes,
any dispute arises in future, then it will be
yes,
dissolved through, sorry,
arbitration.
it will be resolved through arbitration. Okay.
Yes,
And as you mentioned, the place of arbitration will be conducted, the language of arbitration that will be
yes,
conducted in which language, and
mm,
time and everything that is already decided.
yes,
As you mentioned that if the arbitration is going to be held in London or England.
yes,
Mhm.
yes,
So what will be the language, what are the laws that will be followed while
yes,
during the process of that arbitration.
yes,
So everything is decided in that arbitration clause. Because if it is
yes,
international in nature, means two parties coming together or from
yes,
different nation, uh, so they have to come on common agreement. Otherwise, one will ask something like, okay, the dispute will be resolved in my country. Other will claim that the dispute will resolve in my country. So then they
yes,
cannot come on a mutual agreement. Hmm.
yes,
This is the
mm,
reason that they try to to set up the things at third place, neither mine nor yours.
yes,
है ना? So neither mine nor yours place will be the center of dispute resolution. Rather, it will be third place, and neither my law
uh-huh,
nor your law will be.
yes,
Rather, it's a third
mm,
country's law will be followed. So
yes,
these are the things that made party that 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 keeps party something like convenient. Okay, okay, we can
yes,
we can follow
mm,
the things accordingly. So we have the neutral approach, not biasness, no partiality anywhere, so that we
yes,
can
yes,
get the right kind of decision that in favor
yes,
of all, no favorism.
yes,
है ना?
yes,
Okay,
yes.
that's nice. Okay, it's thank you so much. It was really nice one, and giving new exposure to the topic. Okay, so thank you so much, Millie.
All right, thank you.